Figuring out how much your personal injury case will settle for can be confusing, but it doesn't have to be. This video is part 4 in my series on the 12 factors that can have a major impact on the settlement value of your personal injury claim. Now, before we get into the video, a quick disclaimer. This video is not legal advice. It's for educational purposes only. If you've got a question about an injury claim, talk to a lawyer in your state. Now, with that out of the way, let's get into the video. Now, in today's video, we're going to cover factors 8 and 9. Factor number 8 is your medical and billing records. Your medical and billing records can have a major impact on the value of your case. Medical records include things like your x-ray reports from the emergency room, lab tests, MRIs, surgery reports, treatment recommendations, physical therapy reports, etc., etc. Medical records provide a timeline of your treatment from the time of the wreck and your injury until trial. Your medical records can be helpful if they make it clear that your injuries were likely caused by the accident in question. Provide details on the test and treatment that you've received so far, and provide a detailed explanation of the test and treatment that you will likely need in the future. When the insurance adjuster on your claim reviews your file, they will look for reasons not to pay you for your medical bills. This includes things like gaps in treatment. If your medical records show that you stopped treating for an extended period of time, the adjuster may say that you must have recovered from your injuries, and any future treatment after the gap in treatment was for an injury caused by something other than the accident in question. The logic behind this is that if you were still actually hurt, you would not have stopped treating. There would be no gap in treatment. Now, as anybody who has lived on this earth for a number of years knows that life happens and circumstances sometimes can prevent you from continuing with your treatment until those circumstances have passed. So just be ready to explain why there was a gap in treatment in your particular situation. In my experience, adjusters will also scour your medical records looking for potential pre-existing conditions. But in Texas, you can actually recover for a pre-existing condition if it's been aggravated or made worse in a wreck, or if it was asymptomatic, meaning no symptoms prior to the wreck, and then the wreck caused it to become symptomatic. The adjuster on your claim is also probably going to scour your medical records looking for inconsistencies. For example, if your emergency room record shows that you reported pain in your neck, but not your lower back, but then a month later, your physical therapy reports are showing that you're treating an injury in your lower back, the adjuster may pounce on this and say that the lower back injury was not caused by the accident because you didn't report it during your trip to the ER immediately after the wreck. Therefore, the logic goes, it must have been caused by something other than the accident or the wreck or whatever happened that you are bringing your claim for. That's why it's important to report all of your symptoms at the emergency room as early as possible. Even if some of the symptoms are less severe or less painful at the time, it's still important to report everything that you feel, because you never know which parts of the body are going to become increasingly painful over time. Next, let's talk about factor number 9, the strength of your medical expert witnesses. If your case is getting close to going to trial, then your medical experts can have a major impact on the settlement value of your personal injury claim. If you're the plaintiff, the doctors who were actually treating you may serve as the medical expert witnesses in your case. They can testify about your treatment, the cost of the treatment, your future treatment that you need, and what caused your injuries, whether it was the accident or some other thing. In most personal injury cases, the defense will hire and pay for a doctor to come in and testify against your claim as their expert witness. Unlike the plaintiff's treating doctors, the defense expert is being paid directly from the defense attorney. As a result, the defense expert witnesses are usually going to say whatever they think the defense attorney wants them to say. The defense doctor's testimony will often include testimony implying that the plaintiff is either faking their injury altogether, or the defense doctor will come in and imply that at the very least they're exaggerating their injuries for the purpose of this case. The defense expert may also testify that the plaintiff's injuries were caused by something other than the accident at issue in the lawsuit, such as age-related wear and tear of soft tissue rather than trauma. And the defense expert may also testify that the plaintiff's treating physicians charged too much for their treatment and that the jury should therefore cut the medical bills, pay them less than what was billed. Now, a strong expert medical witness is a doctor who can explain how the accident in question caused your injuries, why they treated you in the way that they did, what treatment you will need in the future, and the reasonable cost of your treatment. A strong medical witness is likable and can explain some of the most complicated medical and billing issues in plain English without putting the jury to sleep. A weak medical expert, by contrast, is someone who is hyper-technical, who isn't familiar with the medical records and findings in the case, who doesn't want to be there, who is arrogant or condescending, or who can't support his opinion with actual evidence, reason, and logic when cross-examined by the other side's lawyers. Now, in one of my cases where I represented a plaintiff client who had been injured in a very bad car accident, the defense attorney hired a local doctor to testify as an expert witness against our case. And the defense doctor had never met or examined my client. Nevertheless, the defense doctor testified under oath that in his expert opinion, my client was not really injured and was just malingering, was exaggerating the injuries, despite all of the doctor's opinions who had actually treated him to the contrary. The defense expert went on to testify that his opinion was based almost entirely on his review of my client's medical records. Now, he said that he reviewed my client's medical records and didn't see any injuries other than 2 millimeter bulges that he claimed could have been just age-related due to the age-related process. Now, I'll read a snippet from my deposition transcript of that defense doctor where I was able to raise the value of our case by showing that the defense doctor was unfamiliar with my client's medical records despite testifying that the medical records showed only minor bulging discs in my client's spine. So the defense expert testifies, quote, "So the 2 millimeter bulges that he has could have been just age-related, aging process that you see in a lot of people in their late third decade and fourth decades of life." Now, my client's MRIs actually showed a 3 to 3.2 millimeter herniated disc in his lumbar spine. A herniated disc is a more severe type of injury than a mere bulging disc, and it's more likely to be caused by trauma such as a car wreck rather than just mere age-related wear and tear. So I asked the defense doctor, what about the herniation shown in my client's MRIs? And then he said, well, see, maybe we're just thinking differently. When someone says herniation to me, and then I interrupted and said, that's different than a bulge, correct? He says, it is definitely different than a bulge. And then he goes on to admit that it's different than a protrusion as well, which he was also saying my client had a protrusion but not a herniation. He agrees to that. He says that's true, but there was no if the films, that's the MRI film, implied a protrusion, herniation means that the actual ring of the structure was broken. He's referring to the soft tissue ring, which I go on to clarify with him. I ask him the annular fibers, correct? And he says, right, that the contents protruded out, broke it out, and there's no evidence of that on the MRI studies. And at that point, I'm realizing he is not familiar with my client's MRI studies because they definitely do show that there is a herniated disc where the jelly inside of the herniated disc, the disc soft tissue, was protruding out of the annular fibers. So I then ask him, so the MRI did not state that he had a 3 to 3.2 millimeter herniated disc? And then the defense doctor says, I would have to get back with you. It was not my impression that it mentioned anything of that sort. So there you can see how the defense doctor hurt his credibility as an expert witness and the credibility of his opinion that my client wasn't really hurt based on what he read in the medical records, because it was obvious that he was not familiar with those medical records on which his opinion was based. So that's all I've got for you today. Thank you for watching.